Today, we are discussing the United States Constitution's First Amendment, specifically the Free Speech Clause and a relatively new court doctrine, the Government Speech Doctrine. For today's discussion, Balin, Opal, and Noam will be joining me for a roundtable discussion on a Supreme Court case called John Walker III, Chairman, Texas Department of Motor Vehicles Board, versus the Texas Division Sons of Confederate Veterans, Incorporated. But first, Balin's going to do a quick 60-second Cliff Notes version of the case.
License plates have been around for nearly 100 years. As the years have passed, states began to use these plates to convey government speech, like slogans, promote tourism, etc. Eventually, Texas ventured out, allowing nonprofits the ability to sponsor a license plate by applying for one of their own designs, which then must be approved by the Texas Department of Motor Vehicles Board and enter the Texas Division State of the Confederate Veterans. We can refer to them as SCV now on. Their design includes a square Confederate battle flag framed by the words Sons of Confederate Veterans 1896, along with the standard license plate info, state name, silhouette state, and clearly the license plate number. First attempt in 2009, the plate was denied by the board. In 2010, SCV tried again. Public comment via internet and an open public meeting occurred, as well as letters by elected officials opposing the plate led the board to unanimously reject the plate. Essentially, the public made clear that the Confederate flag was found offensive by many in the public, associating the flag with hate.
Thank you, Balin. Sons of Confederate Veterans, SCV, sued the board and the chairman in 2012, arguing that the board violated the First Speech Clause of the First Amendment, seeking an injunction requiring the board to approve the plate. The district court ruled with the board. A divided court of appeals reversed the district court's ruling. This is where it gets complicated. The appeals court argued that specialty license plates are private speech, and by refusing the design, engaged in forbidden viewpoint discrimination.
Pause! What is the viewpoint discrimination? Essentially, it is when the government discriminates against a speaker based solely on their views.
Thank you, Noam. The dissenting view argued that Texas's specialty license plate designs are government speech, therefore are not violating SCV's First Amendment right, thus have the right to say no to any design.
And to the Supreme Court, granting certiorari. Did the rejection violate the Constitution's free speech guarantees? This essentially could only be argued if license plates are ruled as government speech. Otherwise, this would be clear viewpoint discrimination against the Confederate flag.
According to Joseph Blacher, at the Duke's Law School, government speech doctrine is a relatively new concept. As the doctrine grows, the constitutional exemption it receives is increasingly bumping into another apparently absolute First Amendment principle, requiring that the government be viewpoint neutral when it restricts private speech. The prevention of viewpoint discrimination has long been considered the central concern of the First Amendment. And yet, in some cases, government speech doctrine seems to allow, if not outright, encourage viewpoint discrimination in the extreme.
I wonder if that's a big point. Big point. Thank you, Opal. Justice Breyer delivered the opinion of the court, joined by Thomas, Ginsburg, Sotomayor, and Kagan, reversing the Fifth Circuit's judgment, holding that Texas's specialty license plate designs constitute government speech and are therefore entitled to refuse to issue plates featuring SCV's design. For one's individual right of free speech to be waived and come to the conclusion that the plate is indeed government speech, allowing the government the constitutional right to choose what they present to the public, several factors must be considered.
It is not a simple question of yes or no. For the opinion to come to the conclusion that the precedents of the court offer the framework where a license plate is that of government speech, not from the precedents that they are formed for private speech. The court weighed many factors, beginning with
A. The first check on government speech is the inherent nature of the United States democratic electoral process. It is through the very nature of free speech clause that people may become informed on issues and choose the government. Through elections, they hope they will follow through their expectations. After all, the United States is a republic where elected officials are trusted to implement policy and vote on laws which the voters desire from them. The opinion recognizes that to interpret the free speech clause in any other way, government would be required to offer contrary messages. Their example of government encouraging vaccines through programs would then, if the free speech clause was interpreted otherwise, would need to allow the perspective of anti-vaxxers of an official platform as well. In reference to Pleasant Grove City versus Summa, the case which the court considered as precedent to the opinion of this case states, "It is not easy to imagine how government could function if it lacked the freedom to select the messages it wishes to convey, making clear the government can speak for itself."
Ever since states began adding more than expected state name and ID numbers to their plates, they were communicating messages from the state. Examples are slogans to urge action, promote tourism, or support local industries. The court concludes, therefore, that these messages are state speech.
C. Essentially, perception by the public that license plates are government IDs, which legally have to be on every vehicle. The very fact that Texas is written on every plate in big bold letters shows the plate is that of government. In addition, by statute, Texas owns the designs, including the designs they adopt by the organizations, and it would not be expected that government IDs would permit messages they do not wish to be associated with. Personally, I have always considered the license plates with messages as being in the minimum condoned by the government, and the court agrees. Persons who observe designs on IDs routinely and reasonably interpret them as conveying some message on the issuer's behalf. Moreover, by the SCV wishing to have their logo on a plate, as opposed to just, let's say, having their vehicle covered in bumper stickers with their logo, is to this very point, it would wish to show that the state of Texas endorses their message.
D. The board must approve every specialty plate and maintains direct control over the messages, designs, typeface, and color of the plates.
And finally, Texas may choose how they wish to present to themselves. The court gives the example of plates representing educational institutions, but they do not need to allow plate designs that deride schooling, or plates which say fight terrorism, but don't need to issue plates promoting Al-Qaeda.
Al-Qaeda. F. The court argues that license plates are not traditional forums for private speech. Therefore, they are government speech. This is due to ruling that plates are not traditional public forums, nor are they designated public forums, nor are plates limited public forums. The very nature of the Texas license plate indicates that they did not intend their specialty plates to serve as either a designated or a limited public forum. The court rejects that though they are raising funds through the specialty plate program, that it is an opening for being considered a forum for private speech. The opinion rejects that license plates resemble the precedents of non-public forum from several cases in the past.
Whoa, we need to quickly define the differences between these forums. Here's a quick rundown by the Legal Information Institute from Cornell Law.
1. Traditional public forums include public parks, sidewalks, and areas that have been traditionally open to political speech and debate. Speakers in these areas enjoy the strongest First Amendment protections. In traditional public forums, the government may not discriminate against speakers based on the speaker's view. Doing so is called viewpoint discrimination, which is prohibited under the First Amendment.
2. Designated public forums. Sometimes the government opens public property for public expressions, even though the public property is not a traditional public forum. After opening a designated public forum, the government is not obligated to keep it open. However, as long as the government does keep the forum open, speech in the forum receives the same First Amendment protections as speech in traditional public forums. Examples of designated public forums include
Municipal
theaters and meeting rooms at state universities.
2A. This one is important to the dissent and to the argument SCV is trying to make. Limited forums is a type of a designated public forum. Here, the government limits access to a designated public forum to certain classes or types of speech. However, the government is still prohibited from engaging in viewpoint discrimination. For example, The government may limit access to public school meeting rooms by only allowing speakers conducting school-related activities. It may not, however, exclude speakers from a religious group simply because they intend to express religious views. This is what SCV is arguing. They're arguing that, yes, the license plate is a Texas ID. However, by raising revenue, they are essentially renting out the space where the logo is going to go, and that being considered a limited form. Therefore, it's not government speech. And by them saying no to their logo, they are indeed engaging in viewpoint discrimination, which, as we know from the case, the Supreme Court's opinion disagrees with.
3. Non-public forums are forums for public speech that are neither traditional public forums nor designated public forums. In a non-public forum, the government may restrict contents of speech as long as the restriction is reasonable and the restriction does not discriminate based on a speaker's viewpoint. That would be viewpoint discrimination.
G. And finally, determining that license plates are government speech does not mean that the state can compel a private party to express a view with which the individual disagrees. And following such logic, Texas cannot require SCV to convey the state's ideological message. SCV cannot force Texas to include a Confederate flag on a plate.
So to repeat the opinion of the court, Texas's license plates constitute government speech, thus are entitled to refuse SCV's design, and also any other proposed designs in the future.
Duke Law School professor Joseph Blacher says, government speech doctrine increasingly threatens First Amendment values, both as practical matter because the government is doing more and more speaking, as a theoretical matter because the interests of the amendment has long been thought to protect are precisely those threatened by the doctrine's expansion.
I think this is a fair concern to those who view speech doctrine maybe in a conservative strict sense. Leading up to this case, as there were limited cases offering precedence on government speech, the lower courts were unsure how to deal with it. Will this provide precedent in future cases to aid the lower courts on the differences between speech doctrine and government speech? Could this definition of government speech in the future be expanded, or perhaps retracted?
Could such an evolution of what constitutes government speech be a whole new avenue for public administrators in choosing policy, which previously may have been considered unconstitutional prior to Walker's opinion, thus, according to some, as infringing on First Amendment rights?
The court's opinion coincided with the Charleston church shooting, which arguably made the impact of the ruling stronger. Both for reasons, 3 states, Virginia, North Carolina, and Maryland, removed similar specialty license plates from their states.
What the opinion does not do is outlaw the use of the Confederate flag, which 75% of African Americans living in the southern United States view as symbolizing racism. The opinion allows the board the right to accept the license plate in the future if they so choose.
I can find no evidence that the U.S. courts believe they should or could simply bar the use of the Confederate flag, which would be viewpoint discrimination. But was this decision expanding government speech edging the United States one step closer to Europe's right to freedom of expression and the right to equality, while European states are required to prohibit particularly severe forms of hate speech, incitement of genocide, and advocacy to discriminatory hatred that constitutes incitement to violence, hostility, and discrimination? And this includes the European states' right to use legislation to restrict other forms of hate speech. And that's that. Thanks, everyone. What do you guys think? That's really awesome, isn't it? Yeah? You guys did a great job.
Thank you.
Everybody say, signing off.
Signing
Signing off.
Thank you.